well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. Glad you're with me on the program today. Hopefully you had a good weekend. We're going to be talking with Kostas Moros here in just a moment or two, attorney with Michel and Associates out in California, one of the great legal minds on X/Twitter at Moros Kostas. Going to be talking about the vampire rule when it comes to concealed carry. This is the it's a prohibition on carrying firearms anywhere on private property unless you have been told you're allowed to do so, either with a signage or maybe just a verbal consent. But the default is that every bit of private property is a gun-free zone. Now, there's not really much evidence. In fact, I would say there's no evidence at all of a national tradition for a vampire rule, and yet the Ninth Circuit Court of Appeals recently upheld Hawaii's vampire rule while casting some technical doubt on California's similar provision. We get into this with Kostas Moros, as well as his thoughts on whether or not the Supreme Court will accept a gun ban case and more. Take a look and a listen. Kostas, thanks very much for coming back on the program. It's good to see you, sir.
Thanks again for having me. It's always a pleasure, and I think this is my second or third time on, but it's always fun.
I think this is number two. It feels like more because I quote you a lot at Bearing Arms. I'm not on social media much, but you are one of my regular stopping points when I get on X and want to keep up with everything going on in the world of the Second Amendment. And I ran across a post of yours, I guess it was Friday, that I kind of wanted to delve into this a little bit. I was working on a piece about Megan Walsh and Saul Cornell and their piece at Duke Center for Firearms Law, where they cited a really racist 19th century gun control law to say that, look, we can ban young adults from owning firearms. That statute in question from 1859 in Kentucky also banned minors, freemen, and slaves from possessing a concealed firearm. I'm not really sure that, if that's the best evidence that they got, it seems to be fairly problematic. But you noted as well that in this Ninth Circuit decision upholding the vampire rule, right? So basically all private property off limits to concealed carry unless it's posted, gun owners are welcome. That the Ninth Circuit also relied on, well, first of all, they didn't rely on many laws at all, did they? Just two? Was that their evidence of a national tradition?
Yeah. So to back it up real quick, they upheld Hawaii's version, but struck down California's on a technical difference. So technically, our vampire rule did get struck down, but that's only because the panel drew this weird distinction because California requires a sign, whereas Hawaii allows any form of consent, including the owner saying, yeah, sure, guy outside who's saying I have a gun, you can come in. They don't require a sign. So for some reason, the panel zeroed in on that. I'm not sure why. But anyway, yes, they cited two historical laws. One was a 1771 colonial law from New Jersey, which was titled An Act for the Preservation of Deer. And it was clearly about poaching on enclosed lands. It wasn't about somebody just carrying a firearm or a sword or some other weapon for self-defense. It was about illegal hunting. The other law they cited was one in 1865 that passed right after the Civil War in Louisiana, and it's one of the infamous Black Codes, which it said people cannot enter the premises of another without permission. But the later governor of Louisiana, I think under the Reconstruction era government, 1868, wrote in his memoirs that the act was clearly targeted towards freedmen. It wasn't ever really enforced against anyone other than Black Americans. So, yeah.
That was it. Those two. That's all it took for a national tradition, right?
And they ignored all the other laws because they acknowledged there was a bunch of other colonial laws that were specifically about enclosed lands. So they mentioned, you can't enter on enclosed lands of another. So that's not like inns or taverns that are open to the public. But obviously, if an area is fenced off, you don't assume you can enter it because it's not open to the public, right? So they should have gone with that as the clear majority tradition. But for some reason, I think we all know what the reason was. They zeroed in on these two outliers. Yeah.
Yeah. So first of all, the outliers that they found are problematic, but also the fact that they just relied on two statutes, right? Neither of which, as you say, well, one of which certainly did not really have anything to do. Clearly, if this was about poaching, didn't really have anything to do about carrying a firearm for self-defense. The other one, as you say, was targeted and really aimed at preventing freedmen from exercising their civil rights. But again, how do just two statutes amount to a national tradition, Kostas?
Well, the panel invented this rule that for sensitive places, the standard is lower. They talked about how in Bruin, it was a complete ban on carry, so they have a stricter analogical standard. But because this is sensitive places, the standard is lower. And they kept citing how the Supreme Court had said polling places and courthouses and schools were sensitive in dicta and Heller. And they said, well, there's only a couple of examples of those in the colonial period. And for schools, there's only a couple school rules in the early 19th century, and then in Reconstruction, several states did pass laws banning guns in school buildings. And to be honest, they kind of have a point about the second one. The Supreme Court just assumed in Heller, hey, no, we don't challenge the carrying of guns in schools, but there's no actual relevant history for that until the late 19th century. All you have is some school rules from the early 19th century in which students, but not adults, were prohibited from having arms while at school, which makes sense. I mean, these are people who are watching over these students, even if it is at a university, and they can set ground rules for the students, but that's not the same as a law. And so the panel is kind of, perhaps fairly, using the Supreme Court's line drawing against itself, by saying, well, you guys said schools can be banned with almost no laws to back that up, so we're going to do the same thing here. And that is something I hope the Supreme Court addresses someday, because it's a way to, basically an end run around what they have their analogical test to be.
Yeah, and this is, I think this is an issue here, right, where we're seeing the lower courts and the appellate courts kind of seize on dicta in Heller or in Bruin, and use that to come up with a whole new test, right? And part of it is, I think, because the Supreme Court has repeatedly said, well, we declined to address this particular topic here, right? It's not a part of, Heller wasn't about sensitive places, right? Heller was about whether you could keep a handgun in your home. So on the one hand, the Supreme Court didn't need to get into that, but if they're going to explore or even suggest this stuff in dicta, then that does provide an open door for these courts that have traditionally been hostile to our Second Amendment rights to say, all right, you know what? I'm gonna take that one line and I'm gonna extrapolate a whole opinion out of it, right? Mm-hmm. We saw the same sort of thing with Rahimi, where, in Bruin, the Supreme Court said, look, surety laws are not a good analog to these may issue carry laws. They didn't stop anybody from carrying a gun. You might have had to post a bond before you could carry if you were considered to be a danger to yourselves or others, but it's not historically analogous to a may issue policy. In Rahimi, they used surety laws and affray laws to say, okay, yeah, but you know what? In those cases, the surety law is actually an appropriate analog because we're dealing with somebody who's been deemed by the court to be a danger. And so there is this national tradition of stopping people who've been adjudicated or deemed by a court to be a danger to themselves or others from carrying a firearm, which to me was a little confusing. I'm curious to get your thoughts on, just where do you think the Supreme Court is right now? Should they be, are we starting to see some of the deficiencies maybe in Heller and Bruin in terms of the lack of clarity in what these decisions said beyond the scope of their actual ruling?
Sure. I'm actually, and I've written about this, I'm more bullish on Rahimi than most people in the pro-gun world, because I do have a lot of issues with the Heller dicta, and I think they need to address that. But Rahimi, when we're talking about sureties and affrays, I don't know. I actually kind of bought the majority's reasoning in that this was somebody who was adjudicated to be dangerous. He waived his right to a hearing in the sense of Rahimi. And that's similar enough to, you have surety laws where somebody has to be, somebody has to go in front of, I think it was a magistrate or a judge, and say this person's threatening me, and that person has to post a bond. And if they can't post a bond, they get imprisoned. And same with the affray laws are, of course, a crime. If you threaten people, you could be jailed for that, of course, as well. So I think that's a lot closer than some of the claimed analogs we're seeing, in other cases, like saying a Bowie knife is like an AR-15, even though Winchester rifles weren't banned in the 19th century, So I'm not as, and a few other things Rahimi did. It focused on the founding era, even though the Supreme Court chickened out on definitively saying it has to be founding era, but that's all all their analogs were rooted in the founding era. And it had a lot of examples. So they cited like 9 different surety laws, going back from English history to the 19th century. They cited, for a phrase, they cited 4 colonial restrictions in addition to, Blackstone and the common law and all this stuff. So it's demonstrating that there has to be this numerosity to back up these analogs. And they pointed out how these laws, just like the modern law, would only be in effect while the order was in place. Once the surety period ended, you weren't under any restrictions, just like the federal law. Once you were no longer subject to the restraining order, then you could get your guns back. So okay. I think that's why I'm more bullish on it. I realize, and I take everyone's point that the circuits are going to abuse Rahimi. They're going to cite that not a law, trapped in amber line, blah, blah, blah. But they were already abusing Bruin, so nothing changed. I mean, really, that doesn't bother me because they were going to do it anyway. So really, what we need isn't to wring our hands over Rahimi. What we need is for the Supreme Court to get more involved more regularly, because it doesn't matter what precedent we have. The lower courts are going to keep abusing it, so they need to be more willing to either grant cert or issue summary reversals. That's the real thing that has to happen, I think.
All right. Well, to that end, this week in East St. Louis, we've got the trial over the Protect Illinois Communities Act, their gun ban and magazine ban. In the Seventh Circuit, upheld, at least in a preliminary injunction, the law saying that, in Heller, the majority said that M16s and the like were not protected by the Second Amendment. Well, these semi-automatic firearms, they're like machine guns, so therefore they fall outside the Second Amendment's protections. You've got, what is it? It's no longer Bianchi, it's Snope versus Brown. That's the Maryland assault ban challenge. That's going before the courts in conference. Probably next month, right?
Yeah, we're actually preparing an amicus brief. We're going to submit in the next week on that one. We've helped draft it, so we're excited about that. And when I was just saying a moment ago that the Supreme Court needs to take more cases, they can start with this one because it's on final judgment, so none of the excuses. I know they hate preliminary injunctions, but this is on final judgment. And Justice Thomas just said he hopes they can hear a case soon about which firearms are protected. Now, will the court chicken out in an election year? I hope not, but I hope they grant cert, but we'll know soon enough. And it's going to be pretty admittedly dispiriting if they deny cert now on a final judgment, considering this was one of the cases, like our case in Duncan, which is also awaiting an en banc ruling from the Ninth Circuit. It's one of the cases that was specifically GVR'd after Bruin. So if they GVR a case, send them back to litigate for years only to deny cert after that, that would be pretty disappointing. So we're hopeful that the Supreme Court will finally decide to hear this important issue.
Absolutely. All right. I want to ask you one more thing before we let you go here. Among the many cases that Michel and Associates and CRPA involved in, LA Sheriff's Department versus CRPA versus LA Sheriff's Department. You're also going after Laverne, California, and their outrageous fees for obtaining a concealed carry license. Where does that case stand right now?
Okay, so just recently, a few weeks ago, after I think we were waiting since April, but we finally got a ruling on the preliminary injunction. And it was kind of an odd ruling, kind of like the Ninth Circuit ruling we just got last week or 2 weeks ago. It was better than expected, considering, we had a judge we thought would be pretty tough on us. And she was in some ways. She didn't grant relief for now on the high fees because she said we didn't we didn't state the proposed course of conduct properly, even though Laverne had offered no history in its support. So that was a little disappointing, but we know what we have to do going forward. And she did give relief on the long wait times issue, but just to the specific named plaintiffs. So we need to figure that out too going forward. That I always hate that dodge. But the biggest news out of that ruling was that the judge agreed, although for now she did not agree with us that California has to honor the permits of the other states. She did agree with us that California has to at least allow people to apply for a CCW permit. So what that means is, you're right. She acknowledged that the right to carry doesn't end at a state border, because somebody from Nevada or Arizona can at least apply for a California permit. Because as of today, without any such order in effect, you have no right to carry in California unless you live here. So most Americans are excluded from their right to carry once they cross the state's border. So right now, but how this is all going to be implemented, the judge probably smartly washed her hands of it. She told the parties, give me a proposed order, talk it out amongst yourselves, because there is a lot of code sections involved in that are basically the current penal code is built for only resident applicants. It has stuff like the sheriff will make sure he's a resident of this county. They will provide their driver's license. So we had to go through the whole penal code and draft up a proposed order that would basically nullify all these as to non-residents. So we've sent that to the state. We're hoping to get some reasonableness from the state in terms of not forcing people to come here to do an interview and training and all that. But we'll have to see how that goes, because we'd like it so that, for example, people could take a training course in Arizona, do a police interview over Zoom, mail in their fingerprints instead of coming here to do a live scan. And that would make it far more feasible, we think, for people to get a permit rather than having to arrange 3 different trips to California. So that's where it stands right now. We're hoping to have news on that soon. And submit our proposed order to the judge. I think it's next week. So my hope is by the start of 2025, people will be able to apply for a permit in California if they are non-residents, and hopefully in a process that isn't too painful. It is a California CCW, so it will be somewhat painful, but it's a market improvement over right now. And we're going to continue. Of course, this was just the preliminary injunction, so we're going to continue litigating this case. We're not giving up on the high fees or the long wait time, so we're going to keep going. Yeah, this is just the start.
All right. Kostas, thank you so much for coming on the program. If there are folks who are still dealing with some of these issues, should they still be contacting CRPA and saying, hey, I've got a county or a city that's charging me, $1,500 all told to try to get my concealed carry permit? Is that something you all still want to know about?
We don't mind if people notify us. However, the answer lately has been, we're aware and we're litigating this as an exemplar case. And once we have a definitive ruling, we will use that ruling against we'll send it to the others and say, hey, you guys are taking 2 years to issue a permit. We now have a ruling from a court saying that's unconstitutional. So you are on notice that you are violating a clearly established right, and therefore we can hold the sheriff personally liable for that failure. So that's we don't have the resources to file because every sheriff and county and city in California gets to issue permits. We unfortunately don't have the resource to sue everybody. So what we have to do in situations like this is make an example of someone, establish some precedent or at least a district court ruling, and go from there. So that's what we're doing right now.
All right, Kostas, again, man, thank you so much for your time. I look forward to having you back again very soon. And be sure that you are following Kostas online, Moros Kostas on X. It is, like I said, one of my stopping points on social media every day, and it should be yours as well. Kostas, thanks for everything you do, sir. Look forward to doing this again very soon.
Thanks, Cam. Thanks for having me on again. Have a great day.
And thanks to Kostas for joining us on the program. Looking forward to having him back again here very soon. By the way, tomorrow on Cam and Company, we're going to be talking with Chris Cox, formerly of NRA, now with Secure Our Freedom Alliance, a brand new group that is on the air in a couple of states and plans to go up in several other battleground states between now and November. So we'll be talking with Chris about that on tomorrow's program. Before we get to today's armed citizen story, our good deed of the day, and our recidivist report, let's talk about this for a second. Economists are warning us about massive tax hikes that could hit your your IRA and your 401k hard. With inflation rising and global uncertainty, it is no wonder that central banks and many Americans are turning to gold. Now, if you have not thought about gold yet, now is the time. Trust Priority Gold to help you diversify your savings with gold and silver. Text GOLDEN to 800-405-GOLD for a free gold info guide and see if you qualify for free shipping and storage. Experts agree physical gold is one of the best ways to fortify your savings. Act now to get your portfolio working for you while the market is golden. Text GOLDEN to 800-405-GOLD to learn more. That is GOLDEN to 800-405-GOLD. All right, now let's turn our attention to today's armed citizen story, our good deed of the day, and our recidivist report. We will start there with a case out of Illinois. Headline doesn't really tell the full story here. Westmont man gets probation in gun case. Okay. As it turns out, now already keep in mind, by the way, this is Illinois we're talking about, right? So you have to have a FOID card to possess a gun in your home. You have to have a concealed carry license in order to possess a firearm in public. It's a felony to do so otherwise. And yet what happens when individuals are caught illegally possessing a firearm? Often not much at all. 21-year-old Canuti Collins of Westmont, Illinois, was accused of possessing a unlawful use of a weapon, armed violence, and unlawful possession of a stolen motor vehicle. Those are the original charges that he was facing. According to police in Westmont, officers saw a car back on April 11th that they thought had been stolen earlier in the day in Rockford, Illinois. They followed it to a residence. They saw someone remove the rear license plate. And then when they arrested Collins, they said that they saw the barrel of a handgun sticking out of a backpack that he had on. There was a Glock 19. Had a bullet in the chamber, had a quote-unquote large capacity magazine, which is, again, illegal under Illinois law. And apparently that gun, I think, may have been modified to shoot full auto. So Kennedy Collins could have been charged federally, too. He wasn't. And instead, on August 23rd, he was allowed to plead guilty to a single charge of aggravated unlawful use of a weapon, no firearm owner's identification. So the stolen vehicle charge dropped, the armed violence charge dropped, possession of a unregistered machine gun, I never even filed, right, because the case was kept in local court. And Collins was sentenced to 2 years of probation and 180 days in jail. Now, under Illinois law, he had to serve half of the 180-day jail sentence, but he had already done so. He was in jail awaiting trial. He got credit for 130 days served, so I guess the state owes him like 54 days. I don't know how that works, but yeah, he's already out. Done. Case is resolved. And as I said to Kostas Moros during our interview, we've got a legal challenge trial this week in Illinois regarding the Protect Illinois Communities Act. So ignoring for a second the constitutional problems with banning commonly owned firearms and magazines, this is how the law works in practice. Right? If you are caught illegally possessing a firearm and a stolen car, what happens? Not much of anything, right? You're going to get offered a plea deal. Most serious charges are going to get dropped. And by the time your case is resolved, you may have already spent enough time behind bars awaiting trial that you're free and clear to go. If not, again, maybe you get 3 months in jail. Maybe. Maybe you just get simple probation anyway. In the case of Mr. Collins, the 180-day jail sentence ended up being time served, and he is back out in the streets of Westport, Illinois. Today's armed citizen story from San Antonio, Texas, where police say a homeowner shot a suspected burglar on the city's southeast side over the weekend. The burglar taken into custody with non-life-threatening injuries. It happened, I say it was over the weekend. I'm sorry, this was actually last Thursday, about 5 o'clock in the morning. Police say that they got a call about a burglary in progress. Neighbors told KENS Channel 5 they heard 4 gunshots before officers arrived. Authorities say the homeowner pulled out a handgun, shot the alleged thief, but the thief took off. Nobody was found there at the scene. A 48-year-old man believed to be the alleged burglar found in a detached garage with apparent gunshot wounds a short distance away. He was taken to the hospital with non-life-threatening injuries. He was later placed in police custody. No word on any charges for the homeowner. Wasn't arrested. At this point, sounds like he was acting in self-defense. As the San Antonio Police Department says, homeowners are allowed to protect their person and their property under state law. So investigators do continue to investigate, but as of right now, again, looks like this is going to be ruled a justifiable shooting there in San Antonio. We'll keep you updated on any additional details as they become available. Finally today, our good deed of the day, in the right place, at the right time, willing and able to do the right thing. A Lakewood, Colorado man who saved a driver who had actually passed out behind the wheel on a busy highway. And Myrick said he saw this car veering in and out of traffic on Friday, September the 6th. And when he realized that the driver was actually unconscious behind the wheel, he did what he had to do, even putting his own safety and his own vehicle at risk. He said, I was honking, screaming, yelling, no response. I got my truck in front of hers. I stopped and just let her, bam, right into the back of me. Myrick was driving home from work when he pulled his truck in front of the unconscious driver. He then was able to get out, rushed over to the window to check on her condition. There was an off-duty police officer and off-duty nurse who were both there traveling as well. They jumped out of their cars to help. They were able to revive the woman. They gave her medical attention. Myrick says that he hasn't spoken to her since. He said, I'd just like to know how she's doing, if she's doing okay. The back bumper of his 15-year-old truck suffered minor damage, but he says it was worth it. He said, I'd do it all again without hesitation. A GoFundMe, by the way, was set up to help Ryan repair his vehicle. I am pleased to tell you that it has exceeded its donations. They were looking for $1,000. As of today, they've got $1,255 for Ryan to fix his truck. So there you go. Looks like Ryan in the right place at the right time, willing able to do the right thing, getting recognized by some fellow residents there in Lakewood, Colorado for his heroic actions. All right, that is going to do it for this edition of Bearing Arms Cam & Company. I want to thank you, as always, for being a part of the program. Looking forward to being with you again tomorrow. But be sure to check out bearingarms.com throughout the day today. We're keeping you up to date on all of the latest Second Amendment news and information from all across the nation, including the second attempt on Donald Trump's life over the weekend in 2 months. Plus, we've got news on the what appears to be a self-defense shooting in Massachusetts, where the shooter charged with assault and battery after being hurled to the ground and attacked by a stranger. He used his firearm to defend himself, and now he, as well as the attacker, are facing charges. We've got the latest for you on that as well. So again, be sure to check out bearingarms.com. We will see you back here tomorrow for another edition of Bearing Arms Cam & Company. Again, thanks for being a part of the program today. Enjoy the rest of your Monday, as well as Mondays can be enjoyed. Look forward to seeing you back here tomorrow for Do A Tuesday. Until then, be well, be safe, and be free.